Chair and Logie.
Some of my concerns echo those raised by the Labour member Chris Hipkins around the interpretation of the law and whether that's the problem or whether it was a drafting problem. And I'm grateful that the Minister is here in the House and is speaking and engaging on this bill. However, we've heard from the Minister, as we've heard from other members on this side of the House, that the policy intent was clear, that it was for a 7-day stand down. But I believe if you're bringing retrospective legislation to this House to say what the intent of the law was when it is so clearly different from what was written in the law and from what the courts have decided is the meaning of the law, then the onus really, I believe, should be on you, the government, to provide us with some evidence of your assertion. We have had no evidence of that assertion. We've not had anything in the Hansard debates. We've had nothing in paper from the Minister. We've just had the oft-repeated assertion that that was the intent. We have nothing to back that up whatsoever. And now I would like to speak in my contribution to our SOPs that we've been hearing, we've put forward for this bill, because we've been hearing from government members again that the Greens were being irresponsible for asserting people's legal right to access their legal entitlements, because somehow that's fiscally irresponsible, and a certain definition of fiscal responsibility obviously overrides the rule of law and people's access to their legal entitlements. But I do want to just point out that actually our SOPs clearly demonstrate that we are willing to work with the government to ensure the certainty that they seem to be seeking with this legislation. And that we believe that that certainty can be balanced with what I believe is the primary responsibility of government, which is to seek to build trust in this Parliament and our public institutions. So what we have proposed in our SOPs is to allow a 6-month period for everyone to be able to lodge applications for review, and to require the government to advertise this opportunity. So if it was a genuine mistake, and it's okay to fix that in the future, that's if the government has a particular policy intent that they would like to see implemented, then we'll debate that policy intent on its point. But if you're going to introduce retrospective legislation to deny people their legally established entitlements, a bit more, I think, should be required than what is in front of us with this piece of legislation. I really think the proportionality, government needs to offer more, particularly when we look at the balance of this and somebody who's accessing the entitlements of work and income, who may have missed a bus, whose bus may have been late, who may have been at a tangi or in hospital for a psychotic episode, who misses an appointment at work and income, and they get their entire benefit, or if they have children, half of their benefit cut. The severity of that penalty for what is a completely, in most people's minds, I would suggest, completely reasonable situation or mistake, to be penalised so harshly, and then for the government to come to this House and say, well, okay, a mistake has been made, we'll take that and we will give some of you 6 weeks to be able to put in an application, and we're not going to mention it. And we have to point out that this will be being reported in the media tomorrow, and there will be people who would be entitled to money now if they'd heard about it today, who will hear about it tomorrow, potentially after royal assent, who will not be entitled to money. And that is setting up a situation of grievance. that is completely unnecessary when we could actively seek to build people's trust and confidence and see the government as recognising their wrongs and seeking to right them and give people access to an entitlement. That is possible in this debate, and for members to choose to support our SOPs to be able to deliver that. Because what we're going to get at the moment, Mr. Chair.
Jan Logie.
Thank you, Mr. Chair. And I do need to speak to that kind of process around those who have missed out on money because of the misapplication of the law from 1998 until May 2014. That when they hear this in the news, potentially tomorrow, and they think, oh, I'm an educational support worker, actually, the way the government funds our schools means that actually I need to rely on a benefit when school outside of term time. Gosh, I might be eligible for over each year 3 lots. Quite a lot of money coming up to this Christmas while I'm really struggling to feed my family and doing a fantastic job in schools and helping schools run and our children being able to learn. Gosh, I might be able to, I'd be entitled to this, but I'm a day too late. It's all over the media today, and I didn't hear this in time, and I've missed out. I don't see how anyone in this House can think that is fair. When we have educational support workers, we have seasonal workers in some of the lowest income areas in this country who we know, there are not many job choices in particular areas in this country, and seasonal work, particularly the area the Minister is from, I think, where we know a lot of people are stuck into seasonal contract forestry work, who will have been on and off benefit, whose legal entitlement as of today would be for quite a significant amount of money. But when this goes through and gets royal assent probably tomorrow, can't be sure, they won't be entitled to anything. That is setting up quite a significant impact, and we don't have a regulatory impact statement because we're being told that there is no significant impact of this legislation. Well, I would like to hear the Minister or anyone else tell me how that is not a significant impact. For somebody in a community to have heard about this and then find out from their auntie tomorrow that they were able to claim some money and then they're not, that in real terms, in real life, that's a major impact. And I am at a complete loss to understand how that is not considered a significant impact. And I would also like to speak to the fact that the law was interpreted by the courts in May 2014, and Ministry of Social Development did not change their interpretation of the law or the way they enacted it, knowing, and they were given 2 court rulings telling them that what they were doing was in effect illegal. They continued that practice. And the Minister has told me that she was shocked to find that out. That she had expected, despite this law change apparently having gone to Cabinet around the same time, so knowing that there was a problem there and there'd been a court ruling, that she hadn't checked whether they'd changed their policy. Now that to me raises some pretty significant issues related to the government, either the Minister's oversight or the Ministry's responsibility in informing the Minister. And that does seem to me a very worrying breakdown of relationship. And I am particularly worried that this may not be isolated to this point. There was a report put out by Child Poverty Action last year looking at the interpretation of relationships, and there's a very famous case, the Rooker case, and then the Joy Child report that was instituted by the then Minister Ruth Dyson. I understand them looking at whether Ministry of Social Development had implemented the changes that were signalled by the court at that time, and it found out that they had not. So I am very worried, and the Child Poverty Action Report indicates that they still may not have. And I would quote, if I had it right in front of me, some of the strength of language of that is deeply worrying for me when the courts have the role of interpreting law and the ministries and government have the role in the responsibility to implement it as it has been interpreted. And if that fundamental relationship is being broken on a consistent basis by this government or any government, then we have an absolutely fundamental problem that should worry many people.